This is Barry Zalma speaking for Claim School Incorporated's newsletter, Zalma's Insurance Fraud Letter, for January 1, 2024. This, Volume 28, Issue Number 1 of Zalma's Insurance Fraud Letter, is the first issue of the 28th year of ZIFL. It includes articles and reports relating to insurance, including an article on why false swearing and insurance fraud provides a defense to insurers. Because in common language, the false swearing provision of an insurance policy merely means that if the insured lies under oath, the policy is void, whether the lie is in a proof of loss or at an examination under oath. In Texas and Oklahoma, for example, false swearing is explained this way, quote, where an insured knowingly and willfully overestimates the value of the property destroyed or damaged, the policy is voided, and the insured's right to recover is defeated. You can read the full article and the full 22 pages of ZIFL at the link provided in the blog. Then there are an article including more McClenny, Mosley, and Associates issues, where in this ZIFL's 21st installment of the saga of McClenny, Mosley, and Associates and its problems with the federal courts in the state of Louisiana, and what appears to be an effort to profit from what some magistrates, district judges indicate may be criminal conduct, to profit from insurance claims relating to hurricane damage to the public of the state of Louisiana. And it notes that Louisiana State Police have opened a criminal investigation into the efforts of MMA and Apex Roofing to solicit customers after receiving a complaint by the state insurance department about suspected fraudulent actions related to insurance claims. Then there is an article on the waiver of the right to appeal becomes effective when a convicted insurance fraud perpetrator who defrauded clients by taking premium money and keeping it for his personal expenses then tried to withdraw his plea. And when a criminal defendant's valid guilty plea includes a waiver of the right to appeal, the Fourth Circuit Court of Appeals generally enforces the waiver by dismissing any subsequent appeal that raises issues within the scope of the waiver. However, even if an appeal waiver is valid and applicable, the Fourth Circuit will review a claim that a district court's sentence or restitution order exceeded the court's statutory authority. In United States of America versus Glenda Taylor Sanders, a December 12, 2023 decision of the Fourth Circuit, the defendant sought a change of the sentence and restitution order. You can read the full article and understand why the request was rejected by the Fourth Circuit by clicking on the link on the blog posting. Then there's an article about the fact that there is now available the 4th edition of the Compact Book of Adjusting Property Claims, which on January 2, 2024 is available in Kindle, paperback, and hardback formats. The 4th edition contains updates and clarifications from the first 3 editions, plus additional material for the working adjuster and the insurance coverage lawyer. You can read the full table of contents and more about the book at the link provided in the blog post. Then there's a fictionalized true crime story called The Largest Residential Burglary of All Time, where after 12 months trying to get insurance on over $3 million in jewelry and a like amount of fine arts, a Taiwanese man who was a wanted criminal in his own country convinced 2 American insurers to agree to insure him against the risk of loss to the contents of his home, and his fraudulent claim was something that resulted in an unfortunate settlement. You can read the full story at the link provided in the blog, plus the full 22 pages of this issue of Zalma's insurance fraud letter. Then there are health insurance fraud convictions, including a guilty verdict of a physician who subjected his patients to unnecessary and invasive tests. Payam Tubian, MD, paid kickbacks to physicians for patient referrals and defrauded Medicaid by subjecting patients to unnecessary radiological tests. You can read about his conviction and that of dozens more at the link provided under the caption Health Insurance Fraud Convictions. Then there's an article called about a fraudster who must serve time and lose his residence to pay restitution to his victims. Armando Valdez appealed his 60-month sentence for healthcare fraud after he pleaded guilty. Valdez's conviction and sentence arose out of his scheme to submit millions of dollars in fraudulent medical claims to United Healthcare and Blue Cross Blue Shield for intravenous infusions of infliximab, an expensive immunosuppressive drug. These infusions, purportedly given to patients at Valdez's medical clinic, Gaziel Medical Services, were either not provided or were medically unnecessary. In United States of America versus Armando Valdez, the 11th Circuit Court of Appeal on December 19, 2023, disposed of the arguments asserted by Valdez. You can read the full article and at the blog post at the link provided in the blog. Then there's a listing of other insurance fraud convictions other than health insurance, where a person sentenced and insured in a multi-million-dollar insurance fraud that had returned $7.75 million to the state of New York. Sadaf Bhatti, 40, and his company, Anar Construction and Contracting Corp., pleaded guilty November 2, 2023 in New York State Supreme Court to insurance fraud in the first degree for their role in certified public accountant Stephen Lyon's scheme to defraud the New York State Insurance Fund of more than $18 million. Bhatti was sentenced to 1 to 3 years in prison, and Anar Construction Corp. was sentenced to a 3-year conditional discharge. You can read the full story and multiple other than health insurance fraud convictions at the link provided in the blog post. Then there's an article on the role of an insurer's attorney after the ending of an examination under oath, where the article explains why a well-executed examination under oath is not only one of the insurer's most effective weapons against fraud, it can also be highly instructive for the adjuster. If an attorney is responsible for performing the examination, the adjuster must make clear that it is his or her obligation to provide sufficient factual information supported by legal authority for the insurer to make a decision on the claim. The adjuster should also, if possible, attend the examination to help the attorney and to study questioning techniques. Attorneys whose job it is to ask questions will usually do a more thorough job of an EUO than will insurance claims staff. After the EUO, the attorney will usually suggest additional investigation and also give the adjuster legal advice as to the insurer's rights, duties, and obligations. You can read the full article and the full 22 pages of this issue of ZIFL at the blog as allowed by the link in the blog post. This video was adapted from my newsletter, the full 22 pages of Zalma's insurance fraud letter, which is available at the link provided, and you can subscribe to the fraud letter at a link provided and will be notified of every issue of the fraud letter, which is every 15 days on the 1st and 15th of each month. Thank you for your attention.